Admitting a whole bunch of people.
I'd say go ahead.
Okay, sounds good. All right. Well, good morning. Thanks for everyone joining us today on this webinar for the Minnesota Earned Sick and Safe Time legislation, which went into effect on January 1st of 2024. I'm Anita Drutla. I'm president of New Market Bank, and I'm a member of the Dakota-Scott Workforce Development Board, as well as the chair of the Business Services Committee for that board. During a recent meeting of our Business Services Committee, we identified this topic as something that continues to confuse and complicate the HR function in many small businesses across Minnesota, even though the law already went into effect almost a month ago. So the Workforce Board and Business Services Committee, we had hosted a webinar back last fall on the same topic. That webinar had several attendees and a lot of positive feedback. However, since then, we're hearing that some organizations still have questions. So we decided to put together this follow-up webinar to help employers who still might have some of those questions. Our presenters last fall did such an outstanding job that we wanted to invite them back. So today we're pleased again to have with us David Skovholt with the Minnesota Department of Labor and Industry and Kate Bischoff, an employment law attorney. I'll let each of them give a little bit of background once we start their presenting.
Doing good.
Before we start, here's just a couple last minute details.
Okay.
We are, please note that the webinar is going to be recorded. We hope to
Okay.
have a copy available much sooner
Yes.
than last time.
Well, we're both at Harbor Lane and Fernbrook, whichever one. They're like literally across the street.
The other one was please mute your phone if you wouldn't mind if you're not talking or asking a question.
The Harbor Lane.
The Dakota-Scott Workforce Development Board is hosting the Zoom call on this topic, which is of interest to many employers. Please do not consider any of the contents and information provided during the call as legal advice from either the Workforce Development Board or Dakota or Scott County. And as we go along, please submit your questions in the chat section. I'll be monitoring it as well as I'm sure the presenters will, and just helping to make sure that we get all of your questions after their presentation. So with that, let's get started. And I think, David, you're going to start us off by having a little presentation.
Okay, great. Thank you, Anita.
Yeah.
Thank you for having me back. And I will present. And yeah, just a reminder, please everyone mute if you can. That's helpful for that. And then we'll get screen sharing. Okay, so yeah, we did do a more extensive webinar presentation, and we do have a recorded webinar up on the DLI website, Department of Labor and Industry, if you'd like a more extended version, more detailed version of this. So I'm going to do a brief presentation today. And is it sharing the correct screen? It is. Great. Okay. And so let's just run through some of the overall basics of the law, and as well as I will cover some of the things that we're seeing in conversations with both employers and employees right now, 1 month into this law. So let's start with the basics. Starting January 1 month ago, approximately, this law started, and it requires that employers provide paid time off to employees. So that's the big picture. We have not had a required paid time off law in Minnesota. This is the first one of its kind. Of course, when I say paid time off, it's not for everything, but it is a form of paid time off. And what is it? When we're getting more into the detail, it's being able to take time off to care for yourself, to care for certain family members, or if there's a domestic violence, sexual assault, or stalking situation going on involving the employee, and they need to take time off to address that. So who's eligible? Again, this is there's certain labor laws that are limited for employers of certain gross revenue or number of employees. This law is very broad. This law covers all employees in the state as long as they're working at least 80 hours annually or in a year for an employer in Minnesota. And when we say for an employer in Minnesota, the employer could be located out of the state, but if the work is performed in Minnesota, that's going to fall under this law. There are very few exceptions. Federal employees, also certain airline crews, as well as independent contractors who are not employees, and in certain construction collective bargaining agreements that have a waiver provision. All other industries are covered and included in this law. So on the bottom here, this is kind of the reminder that that does include employees that a lot of employers call temporary or seasonal or part-time, as long as they're working those 80 hours. How much time can be earned? Probably a lot of us know this at this point, but it's 1 hour for every 30 hours worked, and the employer can cap that amount at 48 in a year. One of the things that's confusing is the up to at least kind of language that is in some of the materials when it comes to the 48 hours. And just essentially what that means is that, let's say you had a part-time employee, it's possible if they're working throughout the year and they're earning at 1 hour for every 30 hours work, it's possible they never reach 48. They need to have the ability to reach 48. At that point, the employer can stop accrual for that 12-month period, that benefit year, or that accrual year. Employers can also front load the amounts, giving the amounts at the beginning of the year, and there's several options for that laid out in our materials in FAQ. What the time can be used for, I'm not going to run through all these in detail. I'll just touch on the one that's the most, where we get the most questions, and that's the fourth bullet point here. It's closure of the employee's workplace due to weather or public emergency. And we haven't had so much of that this year with weather or schools, but it really is, it's going to be specific to the employee's workplace. So if an employer has multiple sites, they may close one and may not close another. It depends where that employee works in that situation and whether ESST would need to be made available. The school or care facility, again, closure for weather or public emergency. We've been getting questions around, well, there's a teacher meetings this day or some other thing that's going on. The way the law is set up is for those days that weather and public emergency, when there's an unexpected day off, when parents can't plan ahead or know that there's going to be a day off of school. Paid interaction with the city ordinances. St. Paul and Bloomington have both amended their ordinances to align with the state law, and Minneapolis may do the same. So this may be an issue that is becomes easier for us to navigate, but essentially, like any labor law, you're looking for the standard that is most beneficial to the employee. So for example, Minneapolis's ordinance says that employees cannot, that employers can restrict earned sick and safe time for the first 90 days of employment. So if you're a Minneapolis employer at this point, you'll need to shift to the state rule on that, or the law when it comes to the first 90 days, which is that access needs to be made available as soon as the time is accrued, access to the earned sick and safe time. All right, on paid time off programs, the interaction with your programs, this is the big question that most people have been working on, of course, is how do I make my current plan work with my current plan of paid time off, whether it's sick, vacation, or a bank of PTO that's all together. How do I make that work with this law? And what most employers, of course, are doing is just making sure that they have the minimum number of hours provided to employees that fit the criteria of the law. So if you are providing hours up and above the minimum number of hours, you can set your own criteria for how those are used, for what types of uses that employees can use them for, notification process, different things like that that are different from the law, just like how you would have done 2023 or prior. Those are employer decisions to make. When it comes to the minimum number of hours for the earned sick and safe time law, there's a certain set of criteria, terms and conditions under the law. So that's how kind of thinking about how that works. All right, so a couple more details. Here are some things that we're seeing that all employers haven't quite figured out quite yet. And of course, we're still new with this law, so it does take time. But it's earning statements. So one of the things is adding on earning statements the total number of hours that have been accrued by employees, as well as the total number of hours that were used in the last pay period. And when I say accrued, it's not only accrued, the total number of hours accrued, but it's the total number of hours available to the employee. So it's not if I've accrued 48 and I've used 40, it doesn't have to say 48. It's whatever I have available at that moment. So hopefully I didn't confuse that. And then secondly, what I have available in the last, what I've used in the last pay period. All right, so the employee notice, that's another part of the law, and that is that employers are issuing something in writing, a notice to employees informing them about this law, about the time that's available to them, how they accrue the time, the uses that are available to them for earned sick and safe time, all the different, those different factors. And we have a sample notice on our webpage. So that's probably the easiest way for employers to follow through on this, but you certainly could create your own notice as well. The sample notice is, it's on our webpage. It's in a Word and PDF. So you can take the Word and manipulate it. And if you're going to add it to your handbook, which is one of the requirements, if employers have a handbook, that it is also added to the handbook. Additionally, with the notice, there's a requirement that if the employee's primary language is not English, that it be also provided to them in that primary language. We have about 20 translations, 20 languages translated on our website. If you have an employee who has a primary language that's not translated on our webpage, send us an email and we will get that translated and get that back to you and posted for others. Okay, so foreseeable and unforeseeable use. A reminder here that one of the provisions of the law, it says that if the employer expects the employee to notify them that they need to use the time, they have to tell them how to do that. This is probably a standard procedure that most employers already have in place. Who do you call? Who do you text? How do you notify them that you're going to need time off in a week and a half for a doctor's appointment? But it's just a reminder, have that clear written policy. And of course, give it to employees so they can understand how to do it. Documentation. So a lot of employers who are converting paid time off plans that they previously had to the new one, one of the things is that they had provisions that said, if you're out 2 days, you need to provide a doctor's note, for example. And so the new law says that, or the law says that it's more than 3 consecutive days. So if they're using their earned sick and safe time, that's something that you probably need to modify your current policy or plan. You don't probably need to, if you need to, if it's for earned sick and safe. So that's another thing to look out for. Replacement workers, you can't require the employee use of earned sick and safe time to be dependent on them finding somebody to replace them. I also don't have on this slide, but another bullet point I should have had here is the attendance policies, because that's another thing we're getting called about. So a lot of employers have no fault attendance policies or point systems. So those are prohibited from being used when the employee is using earned sick and safe time. So kind of going back to what I said before, if the person is not using earned sick and safe time, if they're using some other paid time off that's from the employer, the employer potentially could give points in that situation. So making that distinction there. And then here's a reminder, got lots of resources, FAQ, those sample notices, videos, and we are available for calls. We're getting lots of calls, still lots of calls and emails every day, probably around 100 a day on earned sick and safe time. So please contact us if you have any questions, and we're available for that. So that's my really brief run through on earned sick and safe time.
Thanks, Dave.
Yes, thank you. I was trying to hit the unmute and another screen popped up. Right now we don't have any questions in the chat. So, but if anybody has questions, I don't know, Kate, do you have anything like prepared that you want to talk about ahead of time before we get some questions going, or?
Well, I'll talk about the things that my clients have asked me.
Perfect.
And I will tell you that one of the big questions is the attendance policy. And if my client has a PTO policy that is compliant with ESST, they have not split those two things out. And so they have, it's more generous than ESST. And so they're going ahead. But now they have a whole bunch of attendance issues where the person's not been there. What are we going to do? This normally would trigger us talking to the employee, potentially even providing discipline. And the big question we have is, well, what was the time used for, or what do we generally know might be the time is used for? Because if we discipline them for using the time off that's related to ESST, we potentially run into the retaliation provision, and we want to be careful about that. Some employers have separated out PTO and ESST, but when you do that, you're always asking the person why they're not there. And generally, I don't want to know when someone has a disabling condition until they need a reasonable accommodation. I don't want a lot of that information as an employer, because it puts me at risk for discrimination and reasonable accommodation claims. So I generally don't like separating them out unless you really want to get into somebody's business about why they're not there. But if you have them together and now you have to discipline someone and they still have PTO, do you potentially run into the anti-retaliation provision? And if you wanted to super reduce your risk, you don't ever discipline for attendance until they're out of PTO. That's just kind of how it shakes out, because then they used all of the time that was available to them, so that we're not running into the anti-retaliation provision. And if they had the time, they got it paid, we're good. We don't have to do any kind of payout, which is not a requirement under ESST upon termination. But if we're disciplining while they still have time in that bank, you run into that risk. Oh, now we got a hoop ton of
I was
questions.
going to say, now we have some questions. I think sometimes people talking start to spur ideas. So do you want to just run through them kind of like you did last time?
I'll just go. Okay. So going back at the top, if we have a clause in our handbook that says you cannot use sick time until after 90 days, can you still do that? No. Take that bad boy out. Does ESST roll over to the next year up to the maximum? It rolls over up to year 2 of a maximum of 80 hours. So you get 48 in a year, but you can roll over and have in your bank up to 80. Do the staff have to ask to use sick and safe time or request it, or do we have to give it to them automatically if they have the available hours? This is a very fascinating question that we should give to Dave, but let me attempt to answer it first, okay? There's 2 ways that this comes up. If I'm going to be out, do we automatically force the employee to use ESST? Under how the current FAQs are written, we cannot force them to use ESST. If you have your ESST wrapped into your PTO program, you could force them to use the PTO part of it, as long as, again, that you're more than compliant with ESST in your PTO program. But if you have a separate ESST program, it says they may use it. It's not that you are able to require them to use it. So Dave, there you go. Set you up.
All right. Okay. Yeah, I agree. It is a bit of a tricky one. Because, of course, if somebody just calls in and says, I'm not coming in today, that's not going to be sufficient for an employer in that situation. So, I mean, we have said that an employer can say, well, can ask, why aren't you coming in? And of course, the employee can say, I need sick time or earn sick and safe time. The law also has a provision that talks about that the person doesn't need to, and our FAQ talks about, person doesn't need to specifically ask for earn sick and safe time. Everybody's not going to track the name of the law and the acronym and things like that. So I think the intention here is that the employee is notifying the employer that they need to use it in some way or another. And the may part of it is kind of, it is in the law. It does say may. Of course, if the person chooses not to use earned sick and safe time, then they don't fall under the protections of the law. So.
Yeah. So normally what we do here is we say, why aren't you coming in today? Well, I've got a sick kid. I'm like, okay, we'll charge this against your ESST or your PTO. It's only when they say no that you run into that issue. So you might want to start talking to your managers about when somebody calls in, you ask, is it because you got a sick kid, or, what's up? But we don't need to know a lot of information. Remember, we as employers are never entitled to diagnoses or a whole lot of information related to a health condition, whether it's the employees or their family member. So like, you got a sick kid? Okay, we'll put you down for ESST or PTO for that day. That's just how the two questions will generally run. Okay. Can you confirm or clarify? Is it okay to mandate that they let us know prior to the absence that they need to use ESST? No. They need to notify you as soon as practicable. Okay. So let's say I am your employee and I am driving my car to work. I'm going to get there. It's going to be great, but I hit a slip. I have an accident. I break my leg. Okay. To be honest, I'm not going to tell you until I have a cast on. Okay. And so we cannot require that they tell you before. It's as soon as practicable. Okay. That they let you know that this happened. I'm not going to tell you before I get into the accident that I got into the accident, even though an injury definitely qualifies me to use ESST. So we cannot require that they tell us before. Yeah, they get to say in hindsight, yep, I was sick. Yep, I got into an accident. Are workers here on H-2 visas for summer work covered? Yep. I think, to be quite honest, ESST is going to be the biggest headache for state fair vendors. Like, that is just going to be an absolute cluster for them, because that's, whatever is best 12 days of summer or whatever it is. Like, that's 12 days where these people are working a lot of time and now they get sick time. Yeah, everybody gets it. If they are here, if they live in Wisconsin and they're working here, yes, they get it. Okay. Are you able to label ESST as PTO and not separate the two? Yes. Okay. There's lots of benefits that go with that. Okay. The recent guidance provides ways we can calculate an hourly rate when an employer is paid on a commission. Employees are paid an hourly rate of $16 an hour and commission on top of that. Can we pay ESST at the $16 hour like we do for PTO? Yes, provided it is more than the minimum wage, which nobody in the state pays, because everybody's, you can't fire people at $10.75 or whatever the minimum wage is currently. I had it wrong on a slide that I gave to a presentation I gave to a staffing agency, and no one noticed that I had the number wrong because no one pays minimum wage. That was very funny. What if someone has negative PTO for the reasons other than ESST, then has an ESST reason for needing to be out? Do we need to allow them to be out for ESST reason? Your obligation for earned sick and safe time is that you give the time. If you have given more or at the amount that you are required to, that doesn't mean that you are in violation when they're out another time for that sick kid. As long as you've given the time, that's the requirement. Okay, I want to caution you, though, that if you have someone who's got a sick kid and they've used all of their PTO and their kid is going to be sick again, the replacement cost of that employee is not insignificant. You still have to find someone to replace that employee. And the message that you send to the rest of your team is that if you go over your PTO once, now we're going to terminate. That I want you to be careful about that risk, because there certainly is a whole bunch of morale and engagement issues that come up with that.
Kate.
Yeah.
Oh, go ahead,
I
Dave.
was just going to
Sorry.
say the law, there's also a provision that talks specifically about advancing time. So employers could advance time, and then, that rule might happen later.
Yeah.
I think we missed one question above too. just to let
Which
you
one?
know from Sandra's iPhone. Since we have many that have more than 80 hours of PTO and don't list PTO on the paycheck, now I put the paycheck EST PTO of that 80 hours, the rest of the PTO, we won't be listing on the paycheck and do our normal process. I think it's asking, do they need
No,
to?
I was just saying, I'm sorry, it's Sandra here.
That's
Sandra's
okay.
iPhone. I'm just getting multiple meetings. So no, I just spent ESST/PTO. That's what's listed as 80 hours. I upfront all the hours. And they earn it, one every 30 hours, no problem. But that's all I'm listing. The rest of our PTO, because our employees get more than that. So we're just handling it our normal Excel spreadsheet way. So I was just putting it at how we're handling it.
Got it. I wasn't sure if that was a question, like, is that allowed or not? So sorry.
No, if it's
I didn't want to
allowed,
miss it.
that's okay. But that's the easy way. So then you don't have to ask any questions, right?
Well, you need to know
You
which bucket you're coming out of. Right? Because
Well, it doesn't matter. It's still the same. Right?
yeah, if you've labeled it, if you're treating it like PTO, but you've labeled it ESST PTO on the paycheck, yeah, you're good.
Yeah.
As long as you're over the number, you're fine. And we do not have to report this to the state. If we did, poor Dave would be swimming in paper. And we like trees in this state generally. Okay, so if an employee makes more hourly than state mandated minimum wage, can the employee be paid No. Okay, if I make $15 an hour, which is more than minimum wage in Bemidji, okay, let's just pick on Bemidji. They're cold. It's 218. They're weird. Okay, so I make $15 an hour. You can't push me down to the minimum wage for my ESST. You have to pay me at my hourly wage. That if you do that, you're creating liability across the organization, and then you get to meet people like Dave in person, and he might be a lovely, lovely man, but you don't want to meet them in person. Okay. If an employee makes more hourly. Oh yeah, I think I answered that question. I think Alexandra put it in twice. Okay. What other questions do y'all have?
Just making sure that we've got all of them. I know one thing that, we've talked about, which is sometimes a concern, is that, we've rolled our PTO into our ESST because we gave more PTO.
Yeah.
So, we have certain days that, being at a bank, that the Fed is not closed, that we're required to be open, such as the day after Thanksgiving. We have a process for people to put in PTO, right? To ask for time off, and it's kind of a seniority first come, first serve thing. One of our questions is, what are we going to do if all of a sudden everybody calls in sick and you can't really ask because they really wanted the day off, and now we don't have enough people to open our lobbies? I don't know if the state has any, or anybody has any suggestions for employers, small employers who really rely on people being honest about that kind of stuff. And hopefully we have a culture that doesn't have people do that. But especially now that, some of our student workers who are coming home from college are getting this because they've worked 80 hours during the summer.
What I have seen my clients do for those kinds of situations is they do spot bonuses on that day. That if you worked that day, you get an additional $50. And that way you're not running into necessarily the ESST PTO issue that they might be actually sick, because let's face it, Thanksgiving and Christmas, while they're lovely holidays, they are also petri dishes for us all. We all get sick over them, right? But if you have people who are coming in who aren't sick, who don't need to use it, the spot bonuses give an incentive for them to be there, separate and apart from, if I use PTO, they can't do anything about it. Okay. Sandra, you can ask for a doctor's note after 3 days of consecutive time off. You can't ask for a doctor's note before that. So if this was happening on Black Friday, which I've read a handbook that has the holiday as labeled as Black Friday. I love it. It's fantastic. But if you have, they're out for Thanksgiving because they're closed, we're open on Black Friday, unless it's been 3 consecutive days. So the Monday, Tuesday, Wednesday, or Tuesday, Wednesday, we're out Thursday. Now we're gone on Friday. That's when you can ask for the doctor's note. You can't ask for a doctor's note for a single day. Okay. If they call out after a holiday and our handbook says they need to work the day before and the day after, or they don't get paid, we can't do that. No, you can do that. That is separate. The holiday pay is separate for the issue. But they get if they're out sick, they still get to use ESST, but the holiday pay runs per your policy, not per the ESST.
And I agree. And I'll add that if there's a provision that specifically penalizes somebody for using ESST and that wouldn't apply to other days off or other type, then that would be potentially of concern.
Okay. Any other questions? I'm a Pisces.
Kate, is there any other major issues that you get questions about from clients that hasn't been addressed today?
We have dealt with a lot of policy issues, making sure policies include the right information. I have seen some policies that are trying very, very hard to look exactly like the statute on this, which in my personal opinion, is a mistake. You need to provide information so that people know how to use it and what they are entitled to, not all the 11 different point things about who they could use it for. You need to be very careful about, no one wants to read a 75-page handbook. And if your PTO/ESST policy makes your handbook so big, no one's reading it until it's an actual issue. So you can put information in like, we have a PTO policy that allows you to rest and recuperate. And if you have a family member who might be sick or injured or dealing with some sort of criminal action, this is the time you get to take off. Going through every individual and using the exact same language in the statute, I think can create more confusion and it creates a handbook that no one wants to look at. So, okay, the issue of people being out due to weather or school closure is a big concern for employers. Even with COVID out there, carve-outs for critical workers. Is there any thought the agent would address on this issue? Oh, that's for you, Dave.
Yeah. So I have had the benefit. I've been able to speak with many different groups, stakeholder groups, employer groups, government associations of employers. And yes, we've received lots of feedback about things that they would like to see differently in this law, and definitely will expect for different people to be weighing in common legislative session and for there to be discussion around tweaks or updates. We'll see what happens, but I would encourage you to contact those organizations and see what their plans are.
Okay. No, your third cousin on your mother's side does not meet the family definition, but the other important individual could be in that definition. There is a catch-all provision for other people who are important to you, which could be your neighbor, which is not a family member. This is one of those things where I wouldn't include this person in, but I would be generous with employees when they talk about, the neighbor I always take care of, or who is always taking care of me. I needed to be out this day. We'll use PTO or ESST for that. That's fine, but I wouldn't necessarily put it in your handbook. Does reporting need to be monthly or bi-weekly pay stub? Put it on every pay stub. So if you pay it on a weekly basis, twice a month, every 2 weeks, put it on there, okay? But if you can't ask why they're out, how would you know if it's the mother's side fifth cousin? When somebody calls in and like, is everything okay? Or why are you out? I'm out because this person is sick. Okay, we're gonna put this on ESST. Is that okay? Yes, that's generally how that conversation goes. We don't need to know much more than that. Okay. I would really like to see the legislation of, Senator Pappas going, your fifth cousin on your mother's side, but not your fifth cousin on your father's side. That would be really fun language to go. So.
Dave, are you getting a lot of specific questions that haven't been addressed here that maybe would be helpful for the attendees?
So, yeah, I think I should have touched on some of those in terms of the notice. Some employers not getting that out, and then there's yep, and then there is some difficulties with the pay stub requirement.
Hey, Josh, you want to mute yourself?
Yep. Okay. All right.
I thought you had them, Kate. So yeah, I mean, I think some of the details in terms of we talked about the 3 days, more than 3 days for a doctor's note. So it's, yeah, like Kate said, in employer policies that are converting from a previous plan to the new one, and trying to look at some of those things and make sure that all those things are updated. That's some of the things that we're seeing. Of course, we are talking to employees that are contacting us that are telling us their employer has not implemented this at all in any way. So there's a full range of situations that we're hearing about.
So for the pay stub, just quick question. If people are having a hard time with that, is it acceptable to the state if people just put it on a separate piece of paper and give it with their pay stub? Or does it have to, I mean, because I know, like, even us, we've dealt with some issues with the company our third party that provides those, and they've had issues like putting the accrual correctly and stuff. And so we track it and we know where they're supposed to be, but
yeah,
can that be an option for people?
So I would say on that the state law requires it to be on the pay stub, but we are trying to work with employers that are doing their very best to comply with the law. So if somebody's putting it in the envelope with the pay stub, that's pretty much connected to the pay stub. So
It's better than nothing.
Yes.
Absolutely. Remember, Dave's goal is to get you to compliance, not penalize you for not being in compliance. So there's a different goal there. Like, we want you to comply with the law. If you're willfully not doing it, yeah, the state will come down hard. But if you're trying and you're giving the information, the state probably will still have a conversation with you, but it's not going to be the end all existential crisis that sometimes when the state comes calling, it feels like. So I want to be clear about that. Like, if you're trying really hard. Now, if your third party payroll vendor doesn't know how to do this, find a different one. Like, QuickBooks does this. And so, like, it's out there and it's relatively easy. For some of them, it's a drop down menu. For some of them, it is you create a new system, but your vendor should know how to do that. Okay. What are, I'm going to assume, Eve, what are the PTO sick policies that make it where companies don't need to comply with ESST? They're outside the state of Minnesota. If you separated your sick from your PTO, your sick has to comply with ESST. You can do more in PTO, but your sick needs to comply with ESST. But if you only have your sick for when people are actually sick, and it doesn't do the school closures, it doesn't do public emergency closures, it doesn't do family member, it doesn't do the criminal stuff, then your PTO needs to be able to cover that so that you have the right amount of time.
And I think that that makes me think of one of the confusion things that has been coming up, and it's the language in the law and our FAQ and materials that talks about more generous plans. And then some employers are reading that to say, well, if my plan gives more time, then I don't need to comply with these other provisions like the pay stub and the notice and things like that. So the more generous is just saying, yes, you can provide more time. And of course, you know, the law doesn't restrict that, but you still do need to do the other details that we've talked about. So there really isn't one, you know, I look at that question and I say, well, that don't need to comply with the ESST, and I'm not aware of anything that doesn't exist. So if that employee is working in Minnesota.
Yeah. It's going to get very hard if they separate sick and safe time and then vacation. Some will take a long weekend on Thursday, Friday, go on vacation, and then just say they were sick and we can't do much about it and we can't write them up. Yeah, that's going to be a little bit of the issue. That's going to be a challenge for employers. But again, our goal is to make sure that people have the time when they need it, and that we're not being too overly policing, and we're trying to trust our employees. So just to confirm, if we close for a snowstorm and our childcare, then they can use sick and safe time for that day to be paid. Yes. If it's a snowstorm, if it's North Hennepin Community College just had, or Technical College just had a lockdown yesterday, that would apply for them as well. Can employees ask to use their ESST time before they've worked the 80 hours? Yes, they get to ask it as of day one. So if they have, you know, if they work a really long day one and in day two, and they have a sick hour, they can use that sick hour if that's how your minimum time off requirement is used or use is. So a salaried worker, how do you compute ESST hours? Some weeks can be more demanding on time. Yep. Remember, overtime gets counted into the calculation of how much they're accruing. So if you are using a 1 hour for 30-hour worked accrual, and they work a 50-hour week or a 60-hour week, they get 2 hours for that 60-hour week. Okay, so if that's how you're accruing, you have to set it up that way so that even overtime counts. For salaried workers, generally what happens is you're not tracking their hours because they're salaried, and that would be a pain, and people get really crabby when they're salaried and you ask to track their hours. What you generally look at is, are they accruing time that would be compliant with the law in general? Most of the time, your salaried workers are already going to be accruing PTO at more than 48 hours per the year. So that is going to cover, they're getting more than a week and a day off for PTO. So generally what I like to look at is, for your salaried workers in their first year, are they getting 80 hours of PTO? Or are they at least getting 60 hours for the PTO? Because if they're not tracking their time and they're getting more than what ESST would require, you can be pretty comfortable knowing that they're getting the right amount of ESST if you're giving them more than what the minimum would be. If you're not, then you might want to think about hedging your bets a little and getting ahead of that. Because if you have people regularly working 50-hour weeks and they're not, or 60-hour weeks, and they're not getting to they only get to that, 48, then they might complain because they're not getting enough time. They're only getting the ESST. They're not getting other time off, because PTO has been a recruitment and retention tool for well over decades now.
And there is a provision in the law that says that employers can assume that salaried workers are working a 40-hour work week for accrual purposes, so that they're working 40 hours. If they're regularly working less than that, like a 25-hour per week, there's not much of that going on, but a 30-hour per hour week salaried worker, then you could use the actual hour worked.
Yeah. Can you set the limit on the increment that you use ESST? Like, can be full hours or shifts and not the 1.67 that they banked? Yes. However you handle time off in the lowest increment that you handle, that's how you handle your ESST too. So if you do by the quarter hour, or you do half hours or 4-hour increments, that's how you can handle your ESST. Okay.
Yeah, and I mean, the 0.67 part of it, I'll just address, because that's basically, I mean, we have said that employers don't have to really credit an employee with an hour until you've got that hour. So, I mean, an employer might look at that and says that person has 1 hour, the 0.67, when that reaches to the next hour, then now you have hour 2.
Yeah. Everybody having fun? I mean, we're not talking about the FLSA, so it's a little better, right?
Are there any other questions that people have? I think you guys did such a great job in the fall that maybe this was a good reminder stuff, but you guys gave so much information back then that it helped people put policies and stuff in place. So,
There's been a lot of great questions here though, so that's,
yes,
these are good things to review.
And we'll send the recording out afterwards. And really appreciate both Dave and Kate for one being so easy to work with and their expertise.
I agree. With that, I think we can end early. We weren't sure how many questions we would get, so, but I really appreciate you guys coming back on and spending the time with us this morning. Thank you a lot. So,
Having us.
great.
Great
All
to be
right.
here. Thanks, everyone.
All right,
Have a
thank you.
great day. Thank you.